Um, Somewhere, if you read the entire editorial, now this particular magazine is clearly linked, affiliated with the RSS. And if one does read it, if you read, it talks about how somewhere down the line that the Supreme Court is being used as a tool to defame India by anti-India forces, that it's run on the income tax money, the taxpayers' money, and it needs to only work for the benefit of India. So are we mocking the Supreme Court, especially, the wisdom of the top court of the country by using language like this?
Well, in fact, let me make it very clear that the magazine is owned by Bharat Prakashan, not the RSS. It has its own independent views. Now let me come on the merit of the topic that we are discussing. Please remember, I have always maintained Supreme Court is not supreme in the scheme of things in India. It is only supreme so far as the hierarchy of the courts are concerned. And therefore, like our Prime Minister is Pradhan Sevak, the judges are also servants of the people. They are doing service to the people. They are not masters. And therefore, the colonial mindset that some of our judiciary suffers has to go away. Now, when they can open a court for hearing a terrorist case at midnight, and then on one hand they are dismissing a petition for complete ban on the BBC documentary, on the other hand they are hearing the other petitions, then I have a problem, because these two petitions should have been heard together. On one hand you dismiss one side petition, on the other hand you are hearing. I have no issue if they are hearing this petition. They can go into it and see whether what these actual are. And one of the PILs is actually asking for is to reinvestigate the matter, to look into everything, which has Supreme Court has already done it. Secondly, they want punishment for the people that who are involved there. Punishments have also taken place. People from both the sides have been convicted. They are in jail. So what is this purpose, entire purpose of re-looking into the matter? Now, so far as the freedom of expression and speech is concerned, Article 19(2) is very clear that they can have reasonable restriction. The action taken by the government of India is under Rule 16 of the IT rules, which gives them power. Now, this is an interim order. It is not a final order. It goes to the committee. Committee gives a finding and then it is confirmed. That process is still not complete. And therefore, today what we see in Supreme Court, they may hear, but they must also revive that petition suo moto on their own, where they say they will not have a complete ban on the documentary. Both these petitions should be simultaneously heard. Otherwise, it will be a one-way hearing in the court. Therefore, what I want today is that if a court can open in the midnight for a terrorist, if it can go into various other questions, please remember, for an ordinary person, if the nation is first, then comes everything. Then even for Supreme Court, nation is first, and they are there to protect the nation, and the individual rights will be subservient to national interest.
Right.